Donald Trump versus the United States got a very interesting order over the weekend. We saw that the judge came out and said that she's intending to appoint a special master. We got an order that we are going to go through in detail today. The government got a summons in this case. They said, oh, you got a lawsuit here. You got to show up and attend to it. So we'll take a look at that. The DOJ responded. They said, what do you need a special master for if we've already reviewed literally everything that we've already taken? You don't need anybody to come out here and manage any of this for us because we've already seen everything. There's nothing for a special master to do. And then we're also going to see a supplemental filing that came out by Donald Trump and his team, which is substantive, right? They're sort of saying, we've got some additional things we'd like to complain about in addition to what we filed first. And so we're going to start here by taking a look at the order from the judge. In Donald Trump versus United States of America, the judge came out and issued a preliminary order on a motion for judicial oversight. Remember, Trump and his defense team, they said, we do not like what the FBI is doing. They just went in and gobbled up all these boxes of very important materials, and they're just rummaging through it. So Trump and his lawyers, they said, we want a special master appointed to deal with this and make sure that they're properly overseen. This is a 2-page order that came out from the court on August 27th. Says the following. It says, this cause, this is the judge writing, says, this cause came up before the court on Trump's motion for judicial oversight and additional relief filed back on docket 1. Upon review of Trump's submissions and the exceptional circumstances presented, and subject to an opportunity to be heard, we are now finding as follows, ordered and adjudged. The judge says, all right, listen, pursuant to the rules and the court's inherent authority, and without prejudice to the parties' objections, the court hereby provides notice of its preliminary intent to appoint a special master in this case. A hearing on the motion is scheduled for September 1, 2022 at 1 p.m. The hearing shall be conducted at the courthouse, and the parties shall adhere to the following instructions. Before August 30th, defendant, that's the U.S. government, shall file a response and a motion and a supplement, including plaintiff's request for the appointment of a special master. All of that needs to be addressed. And in the response before August 30th, filed under seal, the government needs to know and needs to communicate to us about the following. Provide a more detailed receipt for the property, identifying all the property seized pursuant to the search warrant. That was the raid on August 8th. The judge also wants a particularized notice indicating the status of the defendant's review of the seized property. Right? In other words, what has the U.S. government done with these documents? Have you looked at them? Are they filed? Are they labeled? Did you put them all in little folders with little labels on them? What did you do over there? Including any filter review conducted by the privilege review team and any dissemination of materials beyond the privilege review team. Plaintiff, meaning Trump, shall file a response by August 31st at 8 p.m. and in accordance with the rules, notify each other about responsibilities of a prospective special master, along with other considerations involving the appointment of a special master in this case. Now, we talked about this on our morning walk and talk, which is available for members over at watchingthewatchers.locals.com, where we talk about sort of headlines floating around there. But this case is going to introduce a whole bunch of additional complexities because of the confidential, top secret nature, or at least of what they're alleging exists here. Is this special master somebody who's qualified to review all this stuff? Does he have top secret clearance to review the materials? Remember, FBI says you had stuff that nobody else can possibly see. So they're just going to show it to a special master who's just going to say, okay, yeah, that's privileged. That's not. That's confidential. That's not. Things get pretty complicated. And so the judge is saying, yeah, we got to really flesh this out, right? This issue is also going to come up when we talk about jurors and evidence presented in a courtroom. Do they get to know what's confidential? Right? If the government's claiming it's confidential, you got to prove that. That's an element of the crime. The order should not be construed as a final determination on the motion. And so the judge is saying, I'm just going to wait and hold off on a ruling, but I want this stuff submitted quickly. Okay. The date of this recording is the 29th, meaning that tomorrow and the following date, we've got some deadlines. So the judge sends this order out, and a lot of people raise their eyebrows. They go, what? Special master? Does that mean this whole thing is going to get slowed down a little bit? We also saw a summons come out and go over to the U.S. government, one-page civil summons, Donald Trump versus the United States. Trump filed the suit, and now the summons goes out. Okay, so just like you get, a summons, you get a photo radar ticket in the mail, you've been summoned to court to come pay our tax collection fee. Same thing, except guess who got served? The U.S. government, care of the Office for the Southern District of Florida, third floor here, to the defendant's name and address, summons in a civil action. It says, dear jerk U.S. government, a lawsuit has been filed against you. Within 21 days after service of this summons, you've got 60 days to do something about it. And when you do, send it back over to these lawyers, all right? Lindsay Halligan, James Trusty, and Evan Corcoran over for Donald Trump. Send it over to them. And if you fail to respond, a default judgment is going to be entered against you and you're going to lose your case. So it's the court notifying its own government. Don't you love this stuff? Signed off on here by Deputy Clerk S.J. Adams, submitted over to the U.S. government. We also then get a response from the prosecutors. So after Judge, what's her name? Colleen? I don't remember what her name is. It doesn't matter. It does matter, but I just can't remember right now. After the judge appointed a special master, or at least indicated that she had the intent to appoint a special master, the U.S. government responded. You see here, they filed a 3-page response. It hit the docket on August 29th. Donald Trump versus United States of America. These are the U.S. government prosecutors responding. They're saying, okay, listen, Judge, this is our notice of receipt. All right, we got your little order there. And here is also our attorney appearance, right? This is what's called a notice of appearance. Attorneys have to notify the court that they're appearing before they can actually appear. This is who I am. This is my bar number. This is where I came from. I am licensed in your jurisdiction, this, that, and the other. And so the government is saying, all right, you just served us, but now I am appearing officially. They say, the United States acknowledges receipt of this court's preliminary order. We're not happy about it, but we got it. They say, the undersigned U.S. attorney, Jay Bratt, out of the Office of Counterintelligence, he's appearing on this case, which he's also on the other case. So parallel positions. He says, as directed by the court's preliminary order, the United States will file a public response to the motion coming soon. So they have not responded to the original claim. But they write, the government also, remember, they've got these boxes of documents. They've got 15 boxes of documents, Trump's stuff, Melania's underwear, who knows what they've got in there. Paragraph 4 says, the government also will review the materials obtained pursuant to our search warrant, and they're going to coordinate with the case team and the privilege review team. Footnote 1. Let's see what that footnote says. Footnote 1 says, the redacted version of the search warrant affidavit made public is available, as laid out in pages 31 and 32 of the affidavit. The search was executed both by law enforcement personnel conducting the investigation, the case team, and personnel not participating in the investigation who do the filter processing to protect attorney-client privilege document called the privilege team, right? And we went through that when we went, I think that was on Friday, when we really broke down the entire affidavit. So they've got two teams. Case team, they go do the rating, and then the privilege review team reviews the privilege stuff. Somebody identifies Melania's underwear and somebody else puts it on. So this person now is referencing footnote paragraph 1. We got these two teams now saying, as directed by the preliminary order, a sealed supplemental filing, they say, has a more detailed property receipt report. It was all executed. Judge gave us a particularized notice indicating the status of the seized property. Although the government will provide the court more detail in its forthcoming supplemental filing, they say, the government notes that before the court issued its preliminary order, and in accordance with the judicially authorized search warrant provisions, the privilege review team, as described in 81 to 84 of the search warrant, they identified a limited set of materials that potentially contain attorney-client privileged information. They took it. all that attorney-client privilege information seized by the FBI in the invasion of Trump's home. The search warrant team identified a limited set of materials that potentially contain attorney-client privilege information, completed its review of those materials, is in the process of following the procedures outlined in the warrant. In the warrant, they're going to address any potential privilege issues. They say, additionally, the Department of Justice and the ODNI, which we talked about in the prior segment, are currently facilitating a classification review of materials recovered pursuant to the search. As the Director of National Intelligence advised Congress, ODNI is also leading an intelligence community assessment of the potential risk to national security that would result from the disclosure of these materials, right? And you better brace yourselves for this one. Holy moly. Whatever this damage report assessment is going to come out to be, it's going to be brutal. It's going to be, Trump had a letter from Kim Jong-un, and if anybody got their hands on that, do you know what that would do? The Large Hadron Collider at CERN would literally split the universe into quarks, and we'd all just be floating around. You want that to happen? No? Me neither. That's why he has to be indicted, right? So Jay Bratt and Juan Antonio Gonzalez, these two guys. Yeah. Oh, they're overdue library book prosecutors out of the DOJ. Nice job, fellas. All right. And so you can see several different filings from the DOJ. Donald Trump and his team also submitted an additional filing. Let's see what we have here. This filing from Trump's lawyers is a supplemental filing saying that they've got more to say in their demand for judicial oversight. They are filing a 12-page document, August 26, involving the search raid over at Mar-a-Lago. And they're telling the court, we've got some additional stuff that we'd like to talk about here. They say, look, this supplemental filing responds to the court's request that additional information is provided before this case moves forward. They say, we've got the heavily redacted affidavit, but we've got more stuff to say. They write, Your Honor, Bruce Reinhart in that court over there, they're doing whatever they're doing. But you, Judge, you have jurisdiction to provide the equitable relief sought here. In May, the court went through this process, and they're referencing some case law. They say the relief here sought will have no effect on the separate litigation in the other court. They say it's essentially over, right? The search warrant has happened, the affidavit, all of that stuff is basically done. Case has concluded essentially in that court. So, Judge, whatever you want to do here, you can do it. Don't even have to worry about that. The affidavit has been partially redacted and unsealed. Nothing else to talk about. I mean, if they indict him, then that's a new case. But they haven't yet. Finally, they say service of the motion was made and it's all going to happen. So Trump's lawyers, they tell us this. After months of cooperation, as per and in compliance with the Presidential Records Act, which governs all of these issues between Trump and the government, and without any notice at all, on the morning of August 8th, about a dozen special agents from the FBI executed a search warrant raid. 9-hour search, agents seized documents, including, as we learned today, privileged and potentially privileged materials and other items like photos and handwritten notes. The agents also cracked a personal safe belonging to President Trump, and they seized Trump's passports, one of them active. Shortly after the raid, media organizations sought the publication of certain records related to the search warrant, and the litigation was assigned to Judge Reinhart, who originally approved and signed the search warrant. Several orders followed. Trump's team writes, they say, Judge, today, a heavily redacted version of the affidavit in the support of the search warrant was released. And this affidavit underscores why this motion here should be granted, as it provides almost no information that would allow Trump to understand why the raid took place or what was taken from his home. The few lines that are unredacted raise more questions than answers. For instance, paragraph 3 states in pertinent part, as one of the bases for probable cause, that there are, quote, there are presidential records subject to record retention requirements currently remaining at the premises. It's pretty broad, no? They say this provides a deeply troubling prospect that Trump's home was raided under a pretense of suspicion that presidential records were on his property, even though Presidential Records Act is not a criminally enforceable statute. See Armstrong versus Bush, D.C. Circuit Court, 1991. So how can you send in criminal law enforcement officials with the FBI to conduct a criminal warrant in contemplation of criminal charges, which are all detailed there: obstruction, espionage, administrative act, when the Presidential Records Act is not criminally enforceable? On August 22nd, Trump filed a motion for judicial oversight seeking relief. The motion seeks an order appointing a special master to review the documents seized from Mar-a-Lago on August 8th and to tell the government to stop sifting through Melania's clothes until a special master is appointed. In addition, Trump and his team seeks an order directing the government to provide a more detailed property receipt and return any items seized that were not within the scope of the search warrant, which again was insane, right? They wanted any presidential record from 2017 to 2021. Nuts. They say, in addition, the Fourth Amendment and the concerns that Trump has about it, they say the requested relief is necessary to ensure that Trump can properly evaluate and avail himself of other protections under the rules of criminal procedure. How can Trump know if his Fourth Amendment was violated if he can't know what the nature of the search warrant was or what the investigation was about? How can he file a motion to, dismiss his case if he is indicted, if there's no understanding of what happened there? On August 23rd, the court directed Movement to submit a supplemental filing elaborating on the following. So the court said, give me some more details here. The court, right, was sort of questioning this. Why are you, the judge is sitting there going, what? I don't want anything to do with this case. Why are you filing a lawsuit in my courtroom? The court said, look, I don't know why I even have jurisdiction. Okay. I don't even know what kind of remedy you want. You want an equitable remedy? You want a legal remedy? What do you want? What kind of framework is here that I'm supposed to use? What am I supposed to do? And what type of relief do you want, Judge or Trump? And how is this going to impact Judge Reinert's case and all of that stuff? Right. And so Trump and his people are now responding to this. Every single one of those questions. They say, all right, Judge, I got some answers for you. You want them? Here you go. Paragraph A, they say this court, you, Judge, you have jurisdiction to grant relief here. Why? Well, first of all, we're asking you to appoint a special master. And number two, we're asking you to stop the government, enjoin the government from further review. We also want a further detailed account of the material seized, and we want stuff that it was outside of the scope returned. And they say, well, Judge, those things that we're asking for, it's pretty simple. It's not complicated. We want you to tell them to stop going through the stuff, return what they took that's outside the scope, give me more details and blah. And so they say, well, Judge, look, it's easy. The court to appoint a special master, your authority to do it it's well established right here. Here, look over here. They say the U.S. District Court for the Southern District of New York, they've appointed special masters in two prominent cases. Not even an issue. SDNY, go look up that case. They say, in practice, district courts have on many occasions appointed special masters. Look over here. Southern District of New York in June 2002. In fact, you can take a look here. Justice Manual talks about it. All sorts of people talk about it. Not even complicated, Judge. They say, in addition, this court should exercise equitable jurisdiction because they want this to be enjoined, right? They say, do you want, what do you want? You want money? You want a big, pot of money or what? No, we want you to enjoin them from counting or from cataloging the documents. So it's asking them to stop or to do something. It's an injunction. And the court says, yeah, you can do that too. Or the defense says, you can do that too, Judge. You got the power to do that. The present motion seeks injunctive relief in the form of an order barring the government from further review of the materials. And this court exercises equitable jurisdiction to do some of that stuff. They give us some case law, Florida, 2013, and others. And they say, yeah, Judge, look, our request, Trump's request for a special master is closely related to the request to enjoin further review. And therefore, your ancillary jurisdiction is justified. You can do all this stuff, Judge. You're powerful. Finally, they say this court should exercise its jurisdiction over Trump's property and the receipt for the property. They talk about a framework saying this is an exceptional case where intervention is demanded. They talk about this being an exceptional case. The need of Trump to assess the full contents of the seized materials, that the receipt that they produced was not even remotely adequately detailed, right? It was box A21, box A32. What's in there? His passport, apparently, and apparently a bunch of attorney-client privilege documents as well. So they can just come into your house and they can just say, we seized your living room, the bedroom. We get it when they're, what do you need from Robert's residence? We need the closet, the bathroom, the kitchen would be nice, and we'll take whatever else you got. Oh, I guess that's it. They left a receipt. Here is the receipt. 1 bedroom. Here you go. The government has already confirmed that it improperly seized Trump's passport, and the return of the property has no influence at all on any of the further legal proceedings. They say the government seized materials here. They've already admitted that some of those seizures were overbroad and that item is already being returned. They say the Fourth Amendment is protecting people against wrongful searches and wrongful seizures. They've already seized things wrongfully. So in sum, they write, the law clearly permits Trump to seek the appointment of a special master. They say the law allows him to seek an injunction to get a return receipt for his property, and the court can exercise this jurisdiction, Judge, and you know you can. The court has also directed them to address how this might impact Judge Reinert's case, and of course, that is already mostly done. So they say, in the conclusion, for the following reasons as set forth here, we're asking the following. 1, appoint a special master. 2, stop them from reviewing materials. Supply a detailed property receipt. Number 3, return any items outside the scope of the warrant. Number 4. Very easy. Judge, we'd ask you to set an expeditious briefing schedule coming up and discuss the filings submitted moving forward. August 26th. Respectfully submitted by Lindsay Halligan out of Fort Lauderdale and James Trusty, along with Evan Corcoran on behalf of Donald Trump. So that's one additional supplemental motion filed by Donald Trump in Trump versus United States. And he's demanding a whole slew of additional sort of injunctions to stop the FBI from reviewing the materials. The question, of course, did they already review the materials? Is there anything left for them to go through, or have they already done it all? It sounds like they've already done it, but the judge may still appoint a special master to help facilitate discovery or to help the conversation take place between both sides. We'll have to wait and see. Of course, we will continue to cover that, and I'd appreciate it if you subscribed and joined us on that journey